Okay, welcome. Let's talk about genericide because that's really, really fascinating, right? Even a trademark or a mark that's fanciful and arbitrary, clear cut, like Google or Exxon, Kodak. At what point do these terms become generic? And that's the issue that's actually presented in Google versus Elliott. Now, I will tell you, let me give you some examples of terms that are today considered generic, but were at one point registered trademarks. Frisbee, aspirin, Kleenex. All of these terms have now become generic, and anybody is free to use them as part of their merchant, in their products and services, depending on what they're doing. But what about Google? Well, this was the issue in Google v. Elliott, and don't worry too much about the procedural aspects of the case. I'll talk about how legal system works in module number 5. This is on page 774 of your textbook. Also, if you have an older edition of the textbook, I've also included an actual copy of the court's opinion in module 4 if you want to take a look at it. But basically, Elliott, what he was trying to do is register a number of domain names for the internet, www.blankcom, using the word Google as part of his domain name registrations. And domain names have a whole separate system of sort of a law. But bottom line is Google objected, to Elliott using Google as part of his domain name registrations. And so this went to court. And I thought Elliott actually had a very strong case. He's saying, look, he presented evidence that the public, when they use the word Google, they're using it as a verb to describe internet search, not specifically to refer to, the Google search engine. Think about it, right? Let's say you're using Bing, let's say you're using Yahoo search, or there's another one called DuckDuckGo. There actually, believe it or not, there are lots of different search engines. I still remember Alta Vista, but now, regardless what search engine you're using, when you say, you're probably just going to say, hey, let's Google this, let me search this on the internet, right? And what's interesting is that the trial court, the district court, decided to dismiss this case, didn't even let it go to the jury. I personally thought that was a mistake. And by the way, that decision was affirmed on appeal, and the case was not taken to the Supreme Court. I thought that was a mistake. I thought this was something for the jury to decide whether, as a matter of fact, Google is now become generic. I personally disagree with the court's decision. But if I may justify the court's decision, one could argue that because Google has such dominance in the US market, like I think it's over 95, no lower than 90%, most people are using Google, so that Google's argument was that when people say they're going to Google stuff on the internet, they really mean Google, even if, there's 5-10% who are using other internet search engines, for whatever reason, right? DuckDuckGo, for example, bills themselves as protecting your privacy and not commercializing your data to third parties. So you may want to check out DuckDuckGo as a alternate search engine. But that's probably why Google was able to prevail. I wonder, though, if you look at this case, I am the one that included it in the textbook. It's a 2017 case. It's now 2020. I often wonder if this case was brought again today, would Google still win? Or would at least the judge send the case to the jury and let the jury decide as a matter of fact whether Google is now a generic term? But I just wanted to throw that out there, not because I agree or disagree with the court's decision. Maybe back in 2017, maybe Google, maybe you could argue it wasn't yet generic, but just to let you know sort of how courts, have to reason through these things and make close calls. Now, there's one more case, one more fun case I've included in our trademark unit. It's also in your textbook, the Barbie case, right? And so think about this, right? Let's say you're a musician, right? And you want to sing about the Barbie doll, the Canon Barbie dolls, or you want to sing about some other products. You know, a lot of, you know, I'm going to admit I love hip hop, and a lot of hip hop artists like refer to Gucci and Balenciaga and red bottom shoes, to products, very fancy luxury goods that are in fact trademarked, and can they do that? Is that infringement, right? Think about that. Like if you were a court, how would you decide that? And then we'll talk about the Barbie case in our next video, and then proceed with copyright law.